Glad to see everyone. We have 2 bill hearings today, and then we have a few bills that we're going to work. We do have a few people that are out testifying, introducing bills and tax, and even one of our proponents on this first bill. But we're going to go ahead and get started and just assume that everyone will get here when they get here. So I'll just go ahead. I don't think we have any business to do, so I'll open the hearing on House Bill 2593 and ask our revisor to give us a bill brief on House Bill 2593. Thank you, Jason.
All right, thank you, Madam Chair. Jason Thompson, Revisor's Office. You have the bill brief for 2593. It's a little lengthy, I apologize, but there's a lot of content in this new section, and I won't try to go into all of it. I know you've got several attorneys here to make the case for and against, so I'll just try to get out of their way as best I can. What the bill does is require that a political subdivision hold an open meeting to discuss a contingency fee contract for legal services before approving such contract, and it also requires the Attorney General to approve those contracts. The new section of law would provide what I was just saying, and the definitions are where we kind of start, even though they're at the end of the section. A contingent fee, for the non-lawyers in the room, means any fee that is contingent on the outcome of the matter for which the service is rendered. And then legal services, as defined in the bill, is all services performed by or under authority of a law firm or attorney that constitute the practice of law in Kansas, sort of as you would expect. But legal services does not include several enumerated types of work: bond counsel, collection of unpaid debts, fees, fines, attorneys to recoup costs, including deductibles from insurance companies, assisting with the sale of property, and court trustees to assist with enforcement of support orders. So while those things may be included under the definition of legal services, typically for the purposes of this section, they are not included, so they would not be subject to the rules I'm about to talk about for these contingency fee agreements. All right, subsection A gives you 3 requirements for a governing body to meet prior to entering into a contingent fee contract for legal services. First, the governing body is required to call a meeting for the purpose of considering the contract and provide in the notice or agenda of the meeting issued pursuant to the Open Meetings Act a list of a few things, thank you, that have to be in the notice. They have to include the reasons for pursuing the matter that is the subject of legal services. They have to include the qualifications, experience, competence of the firm that they're trying to enlist for assistance, the nature of relationship between the division or the governing body and the attorney or law firm that's a party to the contract, the reasons it cannot be adequately handled by their current attorneys and supporting personnel, and then a couple of other things that I should just stop reading and let you read at some point. So the meeting notice has to contain all of these issues. And then the second requirement is the governing body has to make a finding in writing of a couple of things. One, that it's in the best interest of the residents of the political subdivision to contract for these services. 2, the legal services cannot be adequately performed by the attorneys and supporting personnel that they already have for the subdivision. And 3, the legal services cannot be reasonably obtained from attorneys under a contract providing for an hourly rate payment rather than the contingent fee option. And then the third thing the governing body has to do is conduct an open meeting and approve the contract in an open meeting. Subsection B then talks about the other half of the bill, the approval by the Attorney General's office of these contingency fee contracts for legal services. So once they've been approved by the governing body of the political subdivision, they are then submitted to the Attorney General along with a list of information that is required to come with it. The Attorney General then has 45 days after submission to decide whether to approve that contract or reject that contract. The reasons to approve the contract would be that the legal matter is the subject of the contract, presents one or more questions of law or fact that are in common with a lawsuit demand or settlement asserting or resolving claims that the state has already addressed or is pursuing in court. Or 2, the legal matter involves claims or issues that are more appropriately within the scope of state enforcement. Or 3, the contract does not comply with the Kansas Rules of Professional Conduct for attorneys that are adopted by the Supreme Court. So those are 3 reasons given in statute that the Attorney General would be allowed to refuse to approve. I don't think I said that clearly before. So they're either approving the contract or they're refusing on one of those 3 bases. If the Attorney General does not act, there is an automatic approval. So that 45 days is mandatory. So they either have to act or not act, or the contract is deemed approved after that 45 days. There is a confidentiality provision for the contract, for the description of the legal matter that is in the proposed contract, and that is subject to your review under KSA 45229, so I thought I'd point that out. That's in there. And then finally, I'll mention that subsection C provides that in any proceeding where their political subdivision is currently represented by an attorney providing legal services under a contingent fee contract that would be subject to this provision, essentially, the Attorney General can appear in that proceeding and request that it be dismissed, or they can intervene and recover damages on behalf of the subdivision that brought that suit. So there's essentially kind of it's not exactly retroactivity, it's more of a right of intervention. And with that in mind, I would point out that you did see this bill last year. I know that's typically the first question I get from a certain member of the committee. You saw this as Senate substitute for House Bill 2228. And when it came over from the Senate, it passed 28-12 over there. It went to conference with this, with the chairperson and the vice chairperson and the ranking minority member. And the House ended up concurring on the action 73-52. And when it went to the governor, it was vetoed, and then there was no motion to reconsider the veto. So that's kind of where it ended up last year. One of the changes was there's not a specific retroactivity provision that requires review of these contracts, but the right of intervention is still in there. Other than that, I think it's basically the same proposal as last time with maybe a couple other small edits. But the big one is that section about specific retroactive review of contracts is not in the bill that was there last year. Happy to answer any questions if I can, or just let all the lawyers behind me do all of the
Just have it
fun work.
out.
Yeah. They know this a lot better than I do, so.
Committee, I'm going to ask her questions, but I'm going to have, since you brought up the governor's veto, do you have it or recall, if my recollection is correct, it was specifically that retroactivity was her reason for the veto, but
Okay. I
okay.
apologize. I did not look at the veto message. I just pulled up the record so I could give you the details, but
Okay.
we can pull the veto message if one of the
Okay.
conferees does.
Yeah, maybe someone could,
that.
one of the conferees could answer that question for us. That would be great. Okay, committee, do you have any other questions for the revisor? Okay, seeing none. Thank you, Jason. Okay, we will now go ahead and have our proponents. We're gonna, we have a lot of opponents, as y'all will see when you look at, gonna give the proponents 5 minutes. Opponents maybe a little bit less, but I would just, we'll get to that. But if you're an opponent, let's try not to, you know, we don't need to hear the same thing over and over. Love to hear what everyone has to say. Want you to have a chance to do that. But just be conscious of what you're saying, if, you know, not repeat too much. So, but we will start out with the proponents. Robert Hutchinson from the Office of the Attorney General. Robert, nice to see you in Judiciary.
Thank you, Madam Chair. Robert Hutchison, Deputy Attorney General. It's good to be back in front of this committee for the first time this year. I've managed to stay across the street most of the time thus far. I will try to keep my comments brief. As the revisor said, this isn't a new piece of legislation for this body, but it has been adjusted from last year to address some complaints, some issues that folks had, like the retroactivity, also adding some explicit confidentiality provisions, and adjusting the sunsetting provision. The sunsetting right now applies only to the confidentiality for materials submitted as opposed to the bill as a whole. The primary crux for the bill is some issues we've seen with municipalities entering class actions as plaintiffs and purporting to represent all counties in the state, in fact, all across the country. So effectively, single municipalities are trying to represent the interests of the state as a whole. which is a duty reserved to the Attorney General to act on behalf of the state. We don't want to interfere with the basic operations, the fundamental operations of municipalities, or try to stand over top of them to tell them how to conduct their business. But we want to assure that we have the ability to assert the state's interests, as well as not duplicate or complicate litigation that is underway. So I would expect very few contracts to be rejected under these provisions, and that this would be a legality or form review like many matters that are already submitted to the Attorney General's office. I'd be happy to answer any questions about the issues with the bill or the process that we'd undertake.
Okay, thank you. I'm assuming there'll be questions, but maybe we'll go ahead and hear from the other proponent first and then do them together.
Thank you, Madam Chair.
Okay, thank you. Okay, we'll now have Eric Stafford. Sorry, there's a typo in our agenda. It says Vice President of Government Affairs, the Chamber. No.
Till March 1, Madam Chair.
Oh, is it March 1? Eric becomes the
Yes.
new president.
Thank you.
Yep.
Been a big day, and I love our members and our board, and I'm thankful. So, yeah, appreciate the opportunity to be here today on the hearing for House Bill 2593. Yeah, this is nearly identical with the exception of the retroactive provision from a bill last year that was passed by the legislature and vetoed by Governor Kelly, dealing with class action lawsuits from local units of government. Became a priority last year, and the retroactive piece was important because of litigation that Ford County, Kansas had signed on to dealing with some claims related to difficulty recycling plastics and how it contributes to global warming, et cetera. But really the crux of this, whether it was the first time this bill was introduced was in 2020 under then AG Derek Schmidt, when they were trying to resolve a statewide settlement related to opioids, similar to the tobacco settlement. But when you had ongoing litigation from municipalities and counties in the state, they couldn't resolve statewide. They couldn't come up with a statewide approach. So this year's version, understand with the concerns from the governor's office, that retroactive provision is not in there. But the issue still remains in terms of if there is a legitimate statewide cause, or if there's a class action that these groups sign on to, we are seeking the approval from the Attorney General with this legislation to say, yes, it's okay for you, for your specific instance, to be involved in one, or if it should be on a statewide appeal, to not have that and let it be a state issue that the Attorney General's office is responsible for. So I will say we had lengthy discussions, meetings. John and I, John Goodyear with the League of Municipalities, one of the provisions that they have heartburn over, really tried to find solution there. We were unable to, back and forth 4 or 5 times, and unable to reach agreement on that specific provision. There was discussion at one of the meetings that we held related to Texas's law in this manner that allows for judicial review of the decision from the Attorney General's office. We do not have a problem with that. I think John's probably going to speak to that today, and that would be fine on our part. I think they were just looking for some additional, we don't want just one person to make, potentially political decision or a decision that could impact their municipality if it's not a statewide effort. But, Texas has a similar provision put in place. I don't think it would by any means get them to be supportive or neutral by any means, but I think they would acknowledge that it probably helps a little bit anyway. So, glad we were able to try to have those conversations and try to work through it. Unfortunately, we couldn't get that one section resolved. But again, I'll just close by saying we appreciate the opportunity to hear this bill again. Hopefully it's enough that if there's no retroactivity that maybe Governor Kelly would be okay with it, let it become law, or hopefully even sign it. So happy to answer any questions, Madam Chair, but do appreciate the opportunity to be here today.
Okay, thank you. Committee, we'll go ahead and see what questions we have for the proponents. Representative Carmichael.
Thank you. Thank you, Madam Chair. My questions are for Mr. Hutchinson. During the course of your testimony, you told us that part, at least, of the problem is that individual cities are attempting to litigate on behalf of all of the cities in the state, if I understood you correctly.
Thank you, Madam Chair. Representative Carmichael, Robert Hutchison, Deputy Attorney General. It was a county attempting to assert as a
Counties.
class plaintiff on behalf of all counties.
Okay.
Yes, sir.
So can you tell us the name of the county, the name of the case, the outcome of the case, or the current status of the case as might be applicable?
Madam Chair, Representative Carmichael, there are actually multiple cases, all from Ford County. One was filed in the Western District of Missouri. We were eventually able to successfully intervene in that case and get it reverted back to state court. And there was another case that is still pending in the District of New Mexico, where they filed, where we intervened, and we had a motions hearing in October, and we are still waiting to hear an outcome on that intervention. So we have one that was in federal court in Missouri that's now back in state court in Kansas, and one that's in federal court in New Mexico.
I would have a second question, but I don't know if that's permissible, Madam Chair.
I think we have time today. Go ahead.
Thank you.
Mhm.
So this is about 2 cases all out of Ford County. In one of those cases, you successfully intervened and apparently got the outcome you wanted. And in the second case, you're awaiting the court's decision on a motion to intervene. Is that correct?
Madam Chair, Representative Carmichael, that's the current state of cases. As the chamber mentioned, we also had the opioid litigation where there were diverse interests represented by the state. The legislature actually had to step in.
Yeah, and that's been resolved now, hasn't it?
Yes.
Thank you.
Okay, committee, what other questions do you have? I'll go ahead and ask a question. I think that in here, the retroactivity piece is taken out, but the right of intervention is in here. But so, but you intervened in that case in Missouri. So is that something we already have in statute that somehow you were able to do that, or do you kind of explain that?
Thank you for the question, Madam Chair. There is an ability to intervene under civil procedure. This makes it explicit that when an issue falls under this statute, it only gives us the right to intervene, but also directs the court to allow that intervention or dismissal without prejudice of that case.
Okay, thank you. Committee, Representative Vaughn.
Thank you, Madam Chair. This question could also be for you. So in terms of the examples that have been given today, they've all been about class action lawsuits as far as I'm aware, but these would apply to any contingency fee agreements, which I'm still reading through all the testimony, but my understanding is that it's much broader than that. So why not just limit the legislation to class action lawsuits?
Madam Chair, Representative Vaughn, it's not just about class action lawsuits. The ones we're currently dealing with are class actions, but those opioid cases that the chamber mentioned, those were all individual cases by municipalities, cities, and counties, plus the state had its own opioid litigation against multiple defendants. So in those cases, those were individual suits where the state was also trying to assert injuries to the state as a whole. And there were complications with the interactions between those suits, with allegations of damages, how to deal with the different defendants in those cases. So it's not always class action. Class action is just the one we're dealing with at present.
Representative Bohai.
Thank you very much, Madam Chair. Thank you so much for coming in and presenting today. My question stems back to what my colleague was asking and then said it was already resolved. It sounded like there was another case that you were going to speak to, and I don't have the history on that, and I was wondering if you could further expound.
Madam Chair, Representative Bohai, is the other case what I mentioned, New Mexico, or that one is still, we're still waiting on a judicial order even allowing intervention. So that one is still going further. The one that we had intervened on was removed from federal court back to state court and is sitting idle right now.
Thank you.
Representative Vaughn.
Thank you, Madam Chair. Mr. Stafford referenced this, but I was wondering if we could get the AG office's opinion on some kind of appeals mechanism. If you would be fine with judicial review, if that's something you're willing to say publicly, or what a potential remedy would be to that.
The legislation definitely doesn't include an explicit judicial review provision. I could see someone taking this up under the Judicial Review Act and would see what a court would say about the applicability of the Judicial Review Act. It has pretty broad language, but I haven't directly examined that question.
Okay, thank you.
Okay, committee, I don't see any other questions. Thank you. We appreciate it.
Thank you.
We do have proponent written only testimony from Roger Gaboni from United States Chamber of Commerce Institute for Legal Reform. And we will now hear from our opponents. We have 7 opponents. Let's just start. I mean, I just would ask you to try to keep it to something around 3 minutes. We're not going to be super strict about it, but make sure you say what you want to say, and then we'll go from there. So I will go ahead and call up John Goodyear from the League of Kansas Municipalities. Hi, John. Thanks for coming. I know you've had a dog in this fight, I guess I'll say.
Thank you, Madam Chair, members of the committee. Grateful for the opportunity to appear in opposition to today's legislation. Just as a general matter, anytime a bill like this comes in front of the league, we take a look at it, and we're going to be concerned with or opposed to anything that steps in and introduces what we consider an unnecessary intrusion into that local decision-making authority. Here, we're talking about the freedom to contract. Because of the limitations that this places on our freedom to contract, we oppose. When speaking to contingency fee agreements specifically, contingency fee agreements are often the only practical mechanism for cities and counties to pursue complex, resource-intensive litigation, and to do so in a way that is cost-effective. So we want to protect that right. We also acknowledge that there is competing interests, valid competing interests on the other side of this equation. The Attorney General has a legitimate role in protecting those statewide interests and pursuing and coordinating litigation when we're dealing with a statewide interest. So when we're looking at this bill, we're not talking about where one side of the equation has a valid interest and the other doesn't. There are legitimately valid competing interests at stake here. So what we should approach this bill as is, how do we strike the appropriate balance? And it's the league's position that this legislation does not strike that appropriate balance. The right balance cannot be an unfettered veto of local claims, the ability to extinguish local claims without an opportunity for redress, without an opportunity for review. A more balanced framework would respect the AG's role while preserving the ability of cities to act when there are local, individual, identifiable, articulable harms at stake. So it's our opinion that this balance can be struck with 2 basic amendments. And Eric with the Chamber mentioned these in our discussions. The first would be a narrowing of the justifications, allowing the Attorney General to step in and either take over a claim or extinguish a claim. That justification language you'll find in the bill. It's page 2, I think it's lines 27 through 36. The primary issue that we have with the justifications is that second justification. We think that that is too broad. We have language in our testimony suggesting how that could be narrowed to address our concerns. It would require a determination by the Attorney General in writing stating what that state interest is and how the local action infringes upon that state enforcement of that state interest. The second thing that we would ask the committee to consider is judicial review. You've heard that mentioned now. Judicial review doesn't undermine the AG's ability to protect legitimate statewide interests, but it ensures that our decisions to deny approval, extinguish a claim, or take over a claim are grounded in clearly articulated standards and are subject to neutral oversight. Madam Chair, we think that there is opportunity here to strike the right balance. We would ask that if the committee decides to work this and moves on this, that you consider amendments similar to the ones that we've suggested in our testimony, and we stand ready to work with the proponents to see if there is any way that we can find an agreement on this moving forward. And Madam Chair, I will stand for questions at the appropriate time.
Okay, thank you. I think we'll hear from the opponents and then all the opponents and then do questions.
Thank you.
Thank you. Okay, we now will have Michael Koss, City Attorney, City of Overland Park. Welcome to our committee.
Thank you, Madam Chair, members of the committee. We appreciate the work that the Attorney General's office, the Chamber of Commerce, and the League have done these last 2 sessions to try and create manageable legislation around this issue. We do think there's value to having a statutory framework to coordinate litigation between municipalities and the AG's office to maximize the benefit to Kansans. But House Bill 2593 doesn't do that right now, as it currently grants the AG's office broad discretion to preempt even arrangements for purely local issues. And as John mentioned, this is because of Section 1B that gives the AG's office the right to veto litigation where the legal matter involves claims or issues that are more appropriately within the scope of state enforcement. And the pursuit of the matter independently by the political subdivision could lead to inconsistent legal outcomes or undermine the state's unified position. Legislation contains no definition of what is appropriately within the scope of state enforcement, and separate lawsuits can always lead to inconsistent legal outcomes. A specific example of why this is too broad is the emerging fire truck manufacturer litigation. In the last decade, fire truck manufacturers, the industry has consolidated. Fire truck prices have doubled. They've gone from $500,000 to $1 million. And fire departments, including ours, have had to wait years to get parts for these trucks. This was actually such a big issue that a few months ago, U.S. Senator Josh Hawley called a hearing on it and accused the companies of deliberately creating backlogs to boost profits, calling it a heist. After that hearing, cities, including Kansas City, Kansas, began taking matters into their own hands, using contingency fee arrangements to sue fire truck manufacturers for monopolistic practices and to recoup those public funds that they paid for those fire trucks. However, if House Bill 2593 was law, the AG could potentially prevent cities from pursuing these claims for local damages. The AG could argue that any suit alleging antitrust claims is more appropriate for the state to enforce, and fire departments pursuing their own claims might lead to an inconsistent outcome if the state ever brought their own claim. That's why this section needs narrowed. I've offered an amendment. John has an amendment. I think there are multiple ways to narrow this provision so that we're protecting the ability of the AG's office to coordinate with municipalities without creating a power to preempt these purely local suits. Finally, as John mentioned, the bill should also be amended to allow a judicial review process in the handful of cities that have legislation like this. I've only seen those containing judicial review and be appropriate for this as well. So thank you, committee, for allowing me to submit testimony. We respectfully request you do not pass this out unless the adopted amendments, the amendments are adopted. I also have the full veto message. If you're interested, and I'm happy to read that at the appropriate time. Thank you.
Okay, thank you. We could, maybe you could send it to, I don't know, is it very long? Okay, then why don't, as long as you're up here, why don't you just go ahead and read it? Thank you.
The governor said, as a strong supporter of local control, I believe the decisions around legal services should be handled by local elected leaders who are on the ground and best know their community's needs. I do also believe that there are times when the Attorney General must work to safeguard the state's interest in issues that cannot be adequately litigated by a local entity on behalf of the entire state. There should be additional work on the legislation to develop clearer language around the Attorney General's engagement. Also, the retroactivity language should be removed to eliminate the perception that the bill is targeted at a specific action rather than sound policy. Until those issues are addressed, I cannot sign this legislation.
Okay, thank you for that. All right, committee will now have Eric Houghton, the Deputy City Attorney from Wichita. Welcome. Thanks for coming.
Thank you, Madam Chair. Members of the committee. I'm Eric Houghton. I'm Deputy City Attorney for the City of Wichita. The City Attorney does, the City of Wichita does rely on the statement that was submitted, and in the interest of time, the number of speakers, I won't read through the entire thing again. I do want to point out some highlights, though, that the City of Wichita does completely oppose this bill and all forms of it in the past. There's no amendment that we feel that would fix this. The city is relying on the home rule authority that's granted to it under the Kansas Constitution, Article 12, Section 5, which does grant it the power, among other things, the power to sue and be sued and to enter into contracts without oversight. And specifically, the language of Article 12, Section 5 does say that the authority granted to the city shall be liberally construed for the purpose of giving to cities the largest measure of self-government. Unfortunately, this bill infringes on that. It doesn't, is contrary to that stated purpose of the Kansas Constitution. And as is the normal practice for the city, Wichita and all the cities of the state, they can go through the normal procurement process for entering in the contract, soliciting bids, evaluating them, and then making a public vote by the governing body to enter into the contract. And this bill proposes to basically usurp that and basically give the Attorney General the right to be able to do that without any input, without any responsibility or accountability to the local government. And that's been the practice for many years. The city of Wichita has already done that. And the city is accountable to its own taxpayers and to its own voters. And each contract that the city enters into is available as a public record. And if a public watchdog or if a citizen is concerned about a contract, they can come and speak to the council about that. Finally, the city of Wichita does oppose the intervention provision. It's another attempt to try to usurp the ability of the city to proceed with its own litigation and to sue when it feels it's necessary for the benefit of its taxpayers. And with that, the city urges the committee to not move forward with this bill.
Okay, thank you. We'll have you wait if maybe someone will have a question when we finish with the opponents. Thank you.
Thank you.
Okay, we now will call Jay Hall with the Kansas Association of Counties. Welcome, Jay.
Thank you, Madam Chair, members of the committee. I'm going to take a slightly different tact since we've already talked about a lot of the sections of the bill. As you see in my testimony, Section 1 talks about having an open meeting for the purpose of approving these contracts. Contracts are already approved in open meetings, so this is somewhat repetitive that we would say that those contracts have to be approved in an open meeting because they already have to be approved. What happens is we have the executive sessions where the city or the county may go into executive session to discuss strategy on the lawsuit and those types of things before they come into the open meeting and actually address the contract itself. But they may address some of the other things as far as strategy and as far as the merits and how they are going to handle the case in that executive session, because those are things that are properly handled in an attorney-client situation. Turning our attention to that attorney-client privilege situation, I do want to mention that I have concerns about whether or not this bill is intended to create an attorney-client relationship between the Attorney General and the various localities, because determining whether or not to sue and how to pursue a matter is something that, as an attorney, I take very seriously. And when you are working on those types of things, you have to really think about the strategy of whether to pursue something on an hourly basis or on a fee basis or on a contingent basis. And so do we want the Attorney General creating an attorney-client situation? Are there situations that might cause problems if we do create that kind of relationship? And finally, what are the ethical concerns and how are we going to safeguard them under the language of this bill? Unfortunately, I don't think that's addressed in this bill, and that is the basis of the opposition of the Association of Counties. I will stand for questions at the appropriate time.
Okay, thank you for being with us. We appreciate it. Ruth Ann French, attorney from Sharp Law. Welcome to our committee.
Good afternoon. Thank you. A little shorter than the last guys. As was mentioned, my name is Ruth Ann French, and I'm a partner at Sharp Law in Prairie Village, Kansas, and I'm an adjunct professor at the University of Missouri, Kansas City, and I'm here today to testify in opposition to House Bill 2593. While the bill may be styled as providing transparency and oversight, it is a dangerous overreach into matters of local control to effectively silence legitimate litigation necessary to ensure Kansas cities and counties can hold corporations accountable when their wrongful conduct has cost our cash-strapped political subdivisions hundreds of thousands or even millions of dollars. This bill is just an example of the Attorney General seeking to have exclusive prerogative as a gatekeeper into the courthouses for claims that Kansas governmental entities may have, even when it's the authority of those cities and counties. I have heard some discussion today about class actions and the example of how those can be abused. But class actions are merely just a mechanism in state and federal courts that allow one county or city to represent others similarly situated to recover each of their own local harms. But there are also stringent requirements in state and federal courts to ensure that a class representative city or county is actually an appropriate and adequate class representative, that they have adequate and responsible counsel, and that any fees being charged by their counsel or going to their counsel are reasonable. That's much of the justification for the bill today, but class actions are already regulated in that manner. And these types of class actions and national litigation have allowed, as you've heard, cities and counties to recover what they've overpaid for prescription drugs like EpiPens in class action litigation, or for the municipal services that counties and cities have had to render to deal with the opioid crisis, or the school resources required to combat the epidemic of underage vaping, allegedly fueled by Juul. And we heard in previous testimony about the skyrocketing costs of fire trucks due to antitrust violations. These are very real monetary impacts that affect cities, counties, and school districts. It shouldn't be up to the policy choices of the Attorney General or even the staff capacity of the Attorney General's office about whether to seek to compensate for these harms. There are already limits on contingent fee agreements through the Kansas Rules of Professional Conduct, also through oversight of courts, and as we've heard from the cities and counties, the contracts are already reviewed by legal counsel, approved by votes, and subject to open records requests to the extent they don't divulge attorney-client privileged information. I would also emphasize that local contracting is one of the best ways to ensure that local control and local accountability. As I mentioned, county and municipal elected officials must have public hearings and face elections on their choices. If county residents in a rural county are upset with being involved in litigation, their voice is much louder in county elections than in a statewide AG election, where few, if any, outside their county would likely care about a municipal contract that got vetoed. The final bit that I'll emphasize is the one that was made earlier about the types of authority that this gives the Attorney General to preempt a contract. And all it requires is simply one question of law or fact that is common with any lawsuit, demand, or settlement that the state has already addressed, previously done with, or is currently pursuing in court, given that the state has been involved in antitrust cases, consumer protection cases, fraud cases. This bill is so sweeping that it would provide effective authority to stop any contingent fee agreement a city, school district, or county wants to enter into. These provisions make the bill likely unconstitutional, but also is going to face jurisdiction stripping challenges within both state and federal courts. Given these issues, the litigation would simply be another unnecessary use of public dollars to pursue these challenges in state and federal courts. Thank you.
Okay, thank you. And if you're willing to stand for questions if anyone has a question? Okay, great, thanks. Okay, Brandon Henry, attorney at Wagstaff and Cartmel. Welcome to our committee. You can adjust the microphone. I think you might need to.
We're going the other way.
Yeah.
Is that okay? Everybody hear me okay?
I think so.
Madam Chair, members of the committee. My name is Brandon Henry. I am a partner with Wagstaff and Cartmel, which is a predominantly mass tort litigation firm in Kansas City. I had grand plans of all I was going to say, and now we have one page of legal pad notes because I'm mindful of the time and also of other people making excellent comments. My firm has a long-standing history, and I'll focus on this particular aspect for purposes of today, of representing Kansas schools in mass tort litigation. And that, at present, that includes representing 7 schools in mass tort consolidation that's in the Northern District of California against Snapchat, TikTok, Meta, meaning Instagram, YouTube, and that is for the targeting of children and the decision and carrying out of a plan to make those platforms very addictive to children. I won't do it today because of time, but I could give you statistics that would knock your socks off about the ways that has affected kids. One that stands out to me, given that I have one, in 2021, 1 in 3 high school girls considered committing suicide. There are links directly to social media usage in litigation. Those cases are presently consolidated in a multi-district litigation. We represented 16 Kansas school districts in the e-cigarette Juul litigation that was resolved a few years ago. And I don't mean to insult anyone by giving this description, but I know a lot of lawyers who do it who still struggle with it. And so let me just say, I've heard discussion of class action. I will not get into that because we just heard a little bit about that. My firm predominantly does mass actions, which is consolidations of individual claims that, for efficiency's sake and uniformity of ruling, end up in one, typically federal court, although there can be state court consolidations. Those clients of ours, the plaintiffs in those lawsuits, maintain their independent claims because they have unique, different injuries, populations, and things of that sort. And so I'm going to focus on that. We are hired in all of those cases. My law firm and others like us are hired on a contingency fee basis. Those decisions are made by local school boards after discussion, public vote. My position is after the issues have been well vetted, any concerns about the contingency fee contract that our clients sign with us has been considered, and they go into those with eyes wide open. The contingency fee contract, and I know that is the overarching, in a case like an MDL, that is an actual asset to Kansas schools and to other entities. It is a no-risk proposition. In the Juul litigation, my law firm, on behalf of our 16 Kansas school districts and others in other states, we advanced literally millions of dollars of our own money in expert fees, travel, deposition costs, you name it. We have aligned interests with our clients because we do not, I feel like a commercial, but we do not get paid if our clients do not have a recovery. That is a risk we take. On the opposite side of that, the moment that a decision is made to have in-house lawyers work on a case or to hire hourly outside counsel, that is taxpayer money going out the door with no guarantee of it being returned, pardon me. Because in that situation, it would be the state or the entity that is advancing those litigation costs, and it can and does add up quickly. And just anecdotally, based on the lawyers, the very good lawyers that oppose us in those cases, I can tell you, you do not want to be paying by the hour for lawyers in these types of complex multi-district litigations, because those numbers will be millions per month in an instant. And so the contingency fee contract protects our clients, those entities. There is the other benefit of that in allowing school districts, in our particular example, to hire the counsel of their choosing is that we get to represent their unique interests. I am from Sterling, Kansas, in Rice County. I now live in Shawnee Mission. My kids go to the Shawnee Mission School District. Those are obviously two very different situations. And just that alone is an example of why each local school board should be allowed to make a decision about whether to enter into one of these cases, and if so, with what representation. And so in those instances, They make that decision, the lawyers represent them, and the contingency fee protects the taxpayers. The other thing, and I mean no disrespect to the Attorney General's office because those are excellent lawyers, but these types of cases that I am talking about are very complex. They are represented by some of the biggest, best law firms in the country. And it requires specialists, people who focus on those things and practice in those areas to represent adequately the interests of individual clients. And so, given my law firm in particular, our experience, and given the track record that we have, it is my view that our clients are well-positioned because of our experience and our track record to maximize their recovery, which in our examples would be to Kansas schools, for vaping epidemic, for social media epidemic, things like that, where real money is having to be paid by these school districts for DARE programs, for disciplinary reasons, for smoke detecting monitors or vape detecting monitors, for additional staff. And that is the focus of our representation, and hopefully in cases like Jewel, the recovery we are able to get them. The other thing I would say about the way that this bill is proposed, in the social media litigation, for example, there is a school district trial, the very first one of its kind, that's going to go to trial in 4 months on June 15th in the Northern District of California. If this legislation were in place now, and another school district wanted to try and retain counsel and file that lawsuit, there would be a delay that would be very difficult to overcome on behalf of that school district. In other words, they would have to do all of the things to jump through the hoops in this legislation and then wait 45 days for the Attorney General's office to decide. And even then, with a thumbs up, deadlines have been missed, opportunities to participate have been missed, et cetera. The position that I am here to advocate for is, at least insofar as the examples I'm giving, the current system works. It protects taxpayers, it protects the autonomy of local school boards, and should be maintained. To the extent that there is some desire to amend the proposal, that is not for me to decide. I'm just here commenting on what's before us. And so my view is that this litigation legislation should not be advanced, and that things continue to go as they do at this point. And I will happily stand for questions at the appropriate time.
Okay, thank you. We appreciate it. Last, we'll have Shannon Kimball from the Kansas Association of School Boards. Welcome to committee.
Good afternoon, Madam Chair. Shannon Kimball. I'm the Government Relations Specialist with the Kansas Association of School Boards. I appreciate the opportunity to appear before you today in opposition to this bill. A little bit about the association, since this is our first time in committee this year. We are a nonprofit membership organization that proudly represents over 330 local boards of education, special education interlocal boards, and the boards of trustees of community colleges and technical colleges throughout the state of Kansas. We have a member-adopted legislative platform that guides our advocacy to you during the legislative session. And an important piece of that is the primary principle that boards of education are governing bodies that have a fiduciary duty to protect the interests of their district, and they carry that out through their constitutional responsibilities of local control over the development, maintenance, and operation of local public schools. In this instance, with this bill, we don't feel that it is narrowly tailored to the purposes that were described by the proponents. We believe that the language in the bill undermines that local governance role for school district boards. We feel that the notice and meeting requirements are duplicative of existing open meeting requirements. And we also think that some of those notice requirements and the communications that are required to the Attorney General and the weird relationship that's created in this bill compel districts to reveal confidential attorney-client communications in their efforts to pursue what they would see as appropriate legal claims on behalf of their district. So I'll just go into that just briefly because I know many of the other opponents have touched on these issues already. But as it relates to school boards, we are a little different than cities and counties, but we still have those core responsibilities, the usual powers of governance under statute that include suing and being sued, entering into contracts, pursuing claims on behalf of the district that we govern. This bill would allow the Attorney General veto power over those decisions, effectively substituting the judgment of an executive, state-level executive officer for the local judgment of the locally elected officials who are closest to the issues and the situation at hand. And those local officials have been elected to exercise that judgment on behalf of their voters. An example of that, the previous conferee mentioned, is the Jewel litigation that some school districts in Kansas participated in. And that was a successful example of this kind of relationship being used by school districts to recover damages for actual harms that were occurring in their schools. The thing that seems somewhat odd and that hasn't been raised is that there are many instances in statute where the Attorney General has a prosecutorial or investigative role as it relates to the business of school districts. So a simple example of that would be COMA or CORA violations. So on the one hand, you have the Attorney General's office playing this investigative prosecutorial role, but this bill seems to set up some kind of almost attorney-client relationship where they are reviewing the board's judgment over this kind of decision on a contingency fee contract, and it feels really odd. I don't know if that really raises an ethical problem as a licensed attorney, but it certainly is something to note. And then finally, just to touch on the attorney-client privilege issues, all of the things that are required to be set out in that meeting notice are very specific reasons that a board thinking about entering one of these contingent fee contracts probably already has discussed at length with their retained local counsel. Retaining local counsel is one of the things that boards do routinely as part of their organizational items. You would expect that a board would have met and talked with their attorney about whether entering a contingent fee contract on a claim is a good idea, and they would have talked about all of those reasons and the reasons why they should do it or they shouldn't do it. Asking the board to reveal those reasons both in a public notice, in a written attestation at a meeting, and then to also provide those to the Attorney General seems problematic in terms of maintaining the attorney-client privilege for the board as an entity. So for those reasons and many of the reasons that other conferees have shared with you already, we respectfully request that you decline to advance this piece of legislation, and I'm happy to stand for questions if you have any. Thank you.
Okay, thank you. Committee will go ahead and do questions now. So who has questions? Anybody? Okay, I'll ask a question. I will ask Mr. Henry a question. My question is, it seems to me this bill is about when a municipality or subdivision has entered into a contract, then the AG is going to review it and decide, is this a good idea or a bad idea? So they're not, tell me how I'm kind of missing the, what I hear from the opponents is, oh, this is just, you're going to take over everything. But it seems like it's more like they're going to approve the contract or, within 45 days. And if it's a local concern that doesn't implicate any statewide interests, they'll do it promptly. They'll approve it. So, it's really not just every single little thing, but it's only if there's a statewide interest is what I'm reading in the bill. So how would you see that differently, apparently?
Thank you, Madam Chair. I guess the first thing I would say is, and this is rhetorical, but who decides each one of those things that you just asked about? It's the Attorney General's office. They decide whether it's local. They decide whether the state has a sufficient interest, and I apologize, I don't have the language in front of me. Without question, you could make an argument that, in my example, the vaping litigation, that affects all Kansas schools. That is a statewide issue. But every school district is different. Every school district decides for itself through its local school board how it's been affected they may have made decisions about how they're going to address that. And so in your particular question, I think that it puts too much power within the Attorney General's office to decide all of those things, where there is already adequate protections of each of those entities to decide for themselves, protections I think they are entitled to, and to manage their own affairs in the various ways that these cases are set up. And then if you asked me one part and now I've talked long enough, I can't remember what the first part of your question was. Okay.
I think you answered my question. Yep. And so, but if I understand, like with the Jewel situation, different counties or municipalities or schools or whoever it was, they were all doing their own litigation. So that's many hours of court time and many attorneys. But if the Attorney General were in that case or some other case to take it over, that would be sort of consolidated. So there wouldn't be as much taking up of local, the districts, the state judicial district courts and such. So what do you think about that?
The MDL, the multi-district litigation, all of the cases that are filed all over the country, the one and only case that got to trial before that entire litigation settled was on behalf of the San Francisco Public Schools. The case settled on about the 10th or 15th day of the trial. And that was the first trial in the consolidation of all of the school district cases filed across the country. They all were under the MDL, meaning one judge or one district was making decisions that ensured uniformity of ruling. It ensured that the discovery that was generated in one case could be used in others. We represented schools in Kansas. So San Francisco Public Schools discovery could be used by Concordia because it was the same witnesses. It was lawyers representing the interests of all of these different school boards doing it at the same time. And I will say, in our particular case, on behalf of our, I think it was 16 school district clients, we recovered on average $66 per student for each of our particular school district's clients. The state attorney general's office did actually separately enter into a settlement on behalf of the state with Jewel that resulted in about $20 per student for the entire state. The difference is, our case, the money went to our particular clients for their actual harms and use. The $20 per student that came in through a separate settlement went to the state treasury, and I don't know what was done with it, and I know the school districts don't know what was done with it. And so that's one of the other differences.
Okay, sorry, it begs another question, but I'm just not going to go there. Okay, other questions? Representative Osmond, that's a question.
Thank you, Madam Chair. I don't have a question, but I do have a comment if the chair would allow me leave to make the comment.
Okay, go ahead.
All right. It's not to any proponent or opponent, but it's more, so we heard this bill last year. I wasn't in favor of it last year. I haven't heard much to change my opinion this year, but I have heard from the opponents, some opponents, that there is language that could reach a compromise. There is a number of opponents here. I don't know if there's a compromise that would reach all of them, but if there's we like having people sit down at the table to hash this out. If that is a possibility, if all the opponents can get to the table along with the proponents, I would be interested in seeing what resulted in that.
Okay, thank you. Other questions? Representative Vaughn.
Thank you, Madam Chair. This would be for Mr. Hall. So I think, as was raised earlier, the only kind of compelling reason for this that I'm hearing is that, there could be situations where there's a statewide interest and it's important to coordinate. Otherwise, I mean, it kind of feels like there's an attempt to, exempt special interests from being able to, or giving them essentially like legal immunity. So I I don't know that I really support the way the bill's written, but I'm intrigued by this idea that you have in your testimony about the right of first refusal. I don't know if you could talk more about that. I wonder if that's a better avenue to pursue than having all of these.
Certainly. So as Representative Osman was mentioning, interest in us possibly having the opponents and the proponents talk this out. We had a meeting and I actually proposed the right of first refusal at that meeting. That was met with a somewhat chilly reception, but essentially it would be the Attorney General would have the option to take up litigation on behalf of the entire state. If they decline to do so, then the local entity could then pursue the litigation on their own. So that would essentially be the right of first refusal, that the Attorney General's office would have the opportunity to take up the litigation if they chose to do so. If they did not, then obviously the local entity could then pursue that.
Thank you.
Okay, committee, seeing no further questions, I'll just draw your attention to the written-only opponent testimony. Joe Molino, Callie Denton, Paul Kramer, David Dillner, Blake Short, and Michael Fleming. And I will close the hearing on House Bill 2593. Thank you, everyone, for being here. We have one more bill hearing on House Bill 2612, and I will ask our advisor if he will give us a bill brief on House Bill 2612.
Thank you again, Madam Chair. Jason Thompson, Revisor's Office. Excuse me. House Bill 2612 modifies criminal sentencing rules applicable in multiple conviction cases, excuse me, where consecutive sentences may be imposed by the sentencing judge, and the sentence for the primary crime is a non-prison sentence. And it does this to provide that the supervision term in these cases will be based on the longest supervision term imposed for any of the crimes. So the statute we're in is KSA 21-6819. It's the criminal code statute about sentencing in multiple conviction cases. And you've got current law in subsection B that begins on page 1 about line 16 that provides in cases where consecutive sentences may be imposed, there are several rules. The only one amended here is number 8, B8, which you can find down at the bottom of page 2 and then onto the top of page 3. And the current law in that subsection B8 provides that if the sentence for the primary crime is a non-prison sentence, a non-prison term will be imposed for each crime of conviction, but the non-prison terms shall not be aggregated or served consecutively. And the bill takes the words aggregated or out. It also adds 2 additional provisions. One, the supervision term will be based on the longest supervision term imposed for any of the crimes, and the durations that are set forth in other law will not apply. So it's just the longest term for any of the crimes. And then 2, the increase or the greater amount that you might receive because of this is not a departure. It's not subject to appeal. This is pretty technical sentencing thing, but obviously it has to do with the supervision term specifically. So it's not the non-prison sentence itself. It's the supervision term that comes with that sentence. So hopefully that kind of clarifies it a little bit. And that's why I think it was brought to you by the court services officers. And it sort of focuses more on the supervision aspect rather than the sentence, the non-prison sentence itself. So I had a couple other notes, but I'll just stop there and see if you have any questions.
Okay, and thank you for that clarification, because we've heard already this year some different bills about consecutive, and so thanks for that explanation. Committee, do you have any questions for Jason? Okay, seeing none, thank you. Oh, I'm sorry. Oh, sorry, did not see your finger up. Representative Carmichael.
Thank you, Madam Chair. Mr. Thompson, I'm very confused by this. Okay. I look at the bottom of page 2. It says supervision term will be based on the longest supervision term imposed for any of the crimes and the supervisions set forth in a bunch of statutes shall not apply. And it says this increase shall not be considered departure and shall not be subject to appeal. Does this just is this an attempt to take away the jurisdiction of the appellate courts to hear appeals? Or does this do something different?
Madam Chair and Representative, that's language that we use a lot that often gets interpreted in that way. So this is the standard language from like the special sentencing rules that you see in the grid statute. Because departure sentences are subject to appeal, this language indicates this is not a departure and it's not subject to appeal essentially for that reason. It's not that they're not subject to appeal. Everything is subject to appeal, that within statutory framework, of course. But if it were a departure, it would be one thing. But because it's not a departure, it's appealed sort of in a different way. So it's a little confusing, but it is standard language, and the courts know what to do with that language because it's within the criminal code. It just means it's not appealed as a departure. You have to have another basis for appealing.
That makes sense.
Okay.
Thank you, Madam Chair.
Yep, that was a good question. Thank you. Okay, seeing no other questions, Jason, we appreciate it. And we will call our proponent, our only in-person proponent, Molly Athon, and she is on WebEx with the Kansas Association of Court Service Officers.
Hello.
Hi, Molly.
Just want to double check you can hear me before I begin.
We can, and we can see you. Thank you. And how do you pronounce your last name?
Athon.
Athon. Okay, great.
Chairwoman and honorable committee members, thank you for the opportunity to provide testimony in support of House Bill number 2612. I am a court services officer in the 1st Judicial District of Leavenworth County. I'm here today as the legislative chair of the Kansas Association of Court Services Officers, or KAXO, which currently represents over 400 court services officers, or CSOs, across Kansas. Court services officers supervise felony probationers as ordered by our district courts. Terms of probation are set by the Kansas Sentencing Guidelines and range from 12 months up to 36 months, meaning cases with multiple felony convictions can have multiple probation term limits. The 2023 Court of Appeals decision in State v. Wilson reinforced this issue when attorneys successfully argued that the defendant had already completed the probation term for one of her convictions in that case, and therefore she did not have to serve the prison sentence on that count when her probation was revoked. This precedent requires CSOs to manage multiple differing felony probation terms within a single case based on the severity level of each individual conviction. This creates a complex tracking burden on CSOs where we must monitor several expiration dates simultaneously to ensure the court doesn't lose jurisdiction over parts of a case. The passage of House Bill number 2612 would clarify that the term of probation supervision in cases with multiple felony convictions is controlled by the conviction with the longest probation duration in a case. This change will allow CSOs to continue to focus on public safety and rehabilitation rather than navigating conflicting statutory calendars. It is also in alignment with the post-release supervision terms in which KSA 223713 clarifies that cases with multiple levels of post-release supervision will be controlled by the longest period of post-release supervision. Thank you for the opportunity to provide testimony in support of House Bill 2612, and I stand for any questions.
Okay, thank you. Committee, do you have any questions for our proponent? Okay, seeing none. Ollie, thank you for being with us. We appreciate it.
Okay.
I don't think there's any questions. Okay. Committee, we also have written-only proponent testimony from Missy Schoen, Phillips County Attorney, Kansas County and District Attorneys Association. And we have one opponent, Emily Brandt, criminal defense attorney. Hi, Emily. Welcome back to committee. How are you? Yep.
Hi, Madam Chair. Thank you for having me back this afternoon. Like she said, my name is Emily Brandt. I'm a criminal defense attorney here in the state of Kansas. You have my written testimony. I know that it is lengthy. It's 3 pages. I hope you'll take the time to read it all. It includes specific examples about how this will impact people on probation. And I appreciate the CSO's perspective, and I appreciate the reviser's brief that suggests that this is about supervision and not sentencing. this is about sentencing. This is 100% about sentencing. And I would urge this committee to not work this bill. I think that this bill is not worth this committee's valuable time. I would note, as I did in my testimony, this exact bill language was introduced during the 2024 legislative session in Senate Judiciary. Senate Judiciary did not work it. At the time, the KCDAA were the only proponents of the bill. And again, in response to the case of Becky Wilson. And if you want to read Becky Wilson's case, you will know that the state got everything they wanted and more. Becky Wilson served every single day of the prison sentence she shouldn't have had to have served because she did successfully complete one of her probation terms. So it's a little tough to hear them still complain about that. But this statute has read the exact same for over 25 years. It has been interpreted by the Kansas Court of Appeals the exact same way since 2017. It has not been a problem since then. It is really not a problem now. It's not about supervision. It is about sentencing. A fundamental rule for criminal sentencing is that for every conviction, you get a specific sentence. And that is the same with probation term. Probation is a non-prison sentence. So if you successfully complete the non-prison sentence, you shouldn't then be subject to having to go to prison on that term. Again, I've got examples in here, but if I've got Jane Doe, right? She's convicted of severity level 7 theft and severity level 5 possession of methamphetamine. That severity level 5 possession of meth carries a 12-month term of probation. The theft carries a 24-month term of probation. Also, again, I guess maybe it creates a complex system of tracking, but it's 12-month increments, 12 months, 24 months, 36 months. I think CSOs could handle it. If Jane Doe goes 16 months without committing any probation violations, she's satisfied the non-prison portion of her sentence for the possession of meth. In month 16, let's say she has transportation issues, she misses a bunch of appointments with her ISO, and she has a relapse. She has a hot UA for methamphetamine. Her probation gets revoked, right? She can't go serve her prison sentence on the possession of meth because she satisfied that sentence. The court imposed a sentence, a prison sentence and a non-prison sentence. She satisfied the non-prison sentence. She met her obligations to society by satisfying the non-prison sentence. It is not then fair to send her to prison for something she's already completed. But the court has jurisdiction to send her to prison, revoke probation on the theft that was 24 months, and send her to KDOC to serve that time. That is how it should work. That is how it has always worked. And again, I have strong concerns about the proposed language amending subsection A8, I think the bottom of page 2 onto page 3, that the supervision durations in 6608 C1 through 4 shall not apply. This doesn't actually say that this is only in this just looks like it blanketly applies to people who have multiple convictions in one case. I think that this would disadvantage criminal defendants who have multiple convictions. I mean, if we take Jane Smith, she's got a criminal history score B, the second highest in the state of Kansas. She gets a possession of meth offense. Her mandatory term of probation under C3 is 12 months. We've got Jack Smith. Jack Smith has a criminal history score of I. He's never been in trouble before. That's the lowest criminal history score in the state of Kansas. But the first time Jack gets in trouble, he's convicted of possession of methamphetamine and forgery. Under C4, the mandatory term of probation for each of his offenses is 18 months, right? It wouldn't be a unitary term of probation, but it's 18 months, 18 months. But because he has multiple convictions, this proposed amendment now says that statutory cap doesn't apply to him. The district court judge could theoretically impose any term of probation it wanted to. It can impose a 60-month term of probation for Jack, who's never been in trouble before. But because Jack has 2 convictions in one case, instead of Jane, who had 1, he no longer gets the benefit of the statutory cap on his terms of probation. And so if you're gonna work this bill at all, I think that language needs to be tailored. I think otherwise you're gonna run into serious considerations that disadvantage defendants in similarly situated situations. It also, again, is just unnecessary. There's already a mechanism in the sentencing guidelines under 6608C5 district courts have discretion to impose longer terms of probation if they think that that's necessary and they make particularized findings. So, you know, if we've got John Doe, he's got a criminal history score of E, he's got 2 convictions, a severity level 7 and a severity level 9. Based on his criminal history score, presumptive probation in both. And he imposes 24-month term of probation for the 7, and usually be 12 months for the 9, but the district court judge goes, you know, John, you keep yelling at people who are walking through your yard or walking, you know, across the street. And at first it was just these threats, but now it's risen to an aggravated assault. I really don't think that 12 months of probation is gonna be enough for you to learn your lesson. So I'm gonna make particularized findings that because you have made continued threats to your neighbors and it has now escalated to aggravated assault, that your term of probation on your severity level 9 is also going to be 24 months. This is already within the discretion of district court judges if they want to impose longer terms of probation. And so there just simply isn't a need for this legislation. I'll leave the rest of my testimony. Again, I've given multiple trainings on probation laws in the state of Kansas, including for continuing legal education. I just don't think that this bill does anything to benefit the criminal legal system or CSOs. And again, this is not about supervision. This is about sentencing. And the fact that it might be a burden on CSOs to track multiple terms of probation, I just simply do not think is a reason to deny defendants a fundamental right to a specific sentence tied to a specific conviction. And I'll stand for any questions.
Okay, thank you, Emily. Do we have questions? Representative Vaughn has a question.
Thank you, Madam Chair. Thank you, Ms. Brandt. I found your example of Jane Doe very helpful in describing how the existing system works. Using that example, could you describe how this bill would change that?
Sure, this bill would change that in the sense that Jane Doe would now have a unitary term of probation for 24 months. And so instead of having an individualized non-prison sentence for each conviction, she would have an underlying prison sentence for each conviction. So I believe it would be 21 months for the theft, 11 months for the probation marijuana. Those would be the underlying prison terms if she messed up probation. The probation term would be 24 months. And so she would have to complete 24 months of probation successfully to avoid any prison time. So that's how it would change. Whereas before, if she successfully completed 12 months of probation, she would no longer be subject to the 11 months for the marijuana possession. She would only be criminally liable for the 21 months on the theft.
And then, if I may, Madam Chair, I had a second. I am reading through the bill in your testimony. I just wondered if you were able to share where the statutory cap on probation for multiple counts, where that was in the bill, if you have that.
It's amending subsection A8. And so it's the bottom of page 2, line 39 is 8. The amendment starts at line 43 and goes through line 3, 4 on page 3. So it says that the supervision term set forth in C1, C2, C3, and C4 shall not apply. And again, that blanketly applies to all multiple conviction cases. And so theoretically, district courts would no longer be subject to those mandatory caps if somebody has more than one conviction in their case.
Thank you.
Okay, do we have any other questions? Okay, thank you. We appreciate it. Okay, committee will now close the hearing on House Bill 2612. And we are going to go ahead and work, hopefully 4 bills. We'll see how we do. The first one is House Bill 2518. 2518. And Jason, could you give us a reminder about House Bill 2518? This one, yeah, we heard on February 2nd.
Madam Chair, Jason Thompson, Revisor's Office. 2518 is the bill that increases the criminal penalties for certain violations of the crime of breach of privacy. It also modifies the culpable mental state for that crime. We talked about going from knowingly to intentionally for that crime. And the increases in penalties are for, in particular, when the victim is less than 18, and then when the victim is under 14 and the offender is over 18, it gets the off-grid penalties like certain other crimes in our code.
Okay, any questions for Jason on this one? Okay, do we have any amendments on this bill? Representative Barrett.
I do. If we could pass that out, please.
Okay, would you like to explain your amendment while we're getting it passed out, or would you like to wait?
I can explain it now, Madam Chair.
Okay.
Thank you. It's very simple, and this is just updating the video language as brought to us by Kansas Peace Officers Association through their recommendation. Just that, we're not seeing too many videotapes anymore, so just clarifying that it's video.
Okay, an updated language. Thank you for that. Any questions for the bringer of the amendment? Jason, I think, has a question or has a comment.
Madam Chair, my apologies. I just noticed the arrow, the line is not quite in the right spot on the last box. In each spot, the box is supposed to point to right after the word image, so that each phrase is image, comma, video, or other recording. And the one on page 6 is before image. It should be after image. But other than that, it looks good.
Okay, thank you for that. Okay, any discussion on the amendment? Representative Carmichael.
I'm sorry, Madam Chair. I may not be reading this correctly, but just looking here by way of example, on page 5 of the balloon, it's numbered as 5, it's actually 2 of the amendment. At lines 36 and 37, we are now going to be saying that what is prohibited is dissemination of any image, video, or other recording, but we are striking photographs and film images. And I'd interpret that as an intent by the legislature to no longer regulate still photographs or images recorded on film. I think we're making a mistake.
Representative Bohai, then Barrett, then we'll see if Jason has a comment.
I think we're keeping the word image there and then comma video or other recording. So I think it's image is implied as photograph. That's my understanding of it.
Mm-hmm. Representative Barrett.
Thank you, Madam Chair. Yeah, that's my understanding as well. Images, looks like it's still there.
So it reads the dissemination of any image, video, or other recording.
Madam Chair, I'm sorry.
Violation. Mm-hmm.
My recollection of rules of construction is when the legislature strikes words like photograph and image, that they intend to accomplish something. They're trying to change the law. And I think it's a dangerous thing to do. I guess it just gives the defense bar more opportunity to keep people from being called to account for their terrible crimes. Go ahead if you wish.
Okay, I may have misunderstood what you just said, but image is kept in here. Yeah, you understand?
That's correct.
Okay, okay.
Photographs
They
were specifically described. Now photographs are being stricken,
okay.
no longer prohibited. Same thing with films. It's okay to do it on film now or to record it on film. We're only prohibiting now videotape. I don't quite understand why we're doing this. I could see adding videotape, but to strike photographs and film, I don't know why you'd want to do that.
Okay, would the maker of the amendment like to explain?
Yep. Madam Chair, thank you. My understanding, this is all, it's the same. So photograph and image, in my interpretation, is the exact same thing. Film or video, in my interpretation, is meaning the same exact thing. It's just video is the more updated term, and it includes more, actually, because video can be depicted in digital form and so many other forms now.
Okay, and Jason, did you have anything to add or thoughts on that?
Thank you, Madam Chair. Jason Thompson, Revisor's Office. So I understand the argument that anytime you change words, you mean something by it. That's what I live with. Two points, I suppose. In the underlying bill, one of the updates is to go from using a camcorder, motion picture camera, et cetera, to using sort of any device or software to record or view. So we're already going down this road of deleting things that exist but are not really used and going with broader, more technologically updated terms like device or software in their place. So the intent, as the drafter and the person who was asked to do it, was to broaden what is meant by videotape, photograph, film, or image to cover all of those things plus more. And you could do that by saying image, video, or other recording. And if I'm a defense attorney, I am making the argument that they didn't mean to include videotapes anymore. I don't know if that's a winning argument, but I'm making that argument because it's my client and I have to, right? But the wording should cover all of those things and more. That is the intent of the language, and it does. It's also more technologically neutral, I suppose, which was the other goal.
Okay, thank you. I appreciate that. I think the intent of the legislature is an important thing to note. Representative Lewis.
Right, so I've litigated in this area quite a lot, and I think the word image is the term that's usually used to broadly describe whether it's on a piece of paper as a photograph or in a digital form. In any event, you have something you're looking at, an image, and so I think that's how I would read the amendment, as broadening the scope of the law.
Okay, any other comments? Representative Carmichael, you had a comment?
Yes, and I'm looking again at the bill, but I think the word image is already in the statute. So if image broadens, videotape, et cetera, that's already been accomplished. Because we're not adding the word image. Rather, we are striking words, evidencing the legislature's intent to no longer make it a crime to film these types of activities or to photograph them, because we're taking those words out.
Representative Barrett.
Thank you, Madam Chair. I'll make the same argument again. We just believe image is the same thing, and like the revisor did add, we also added the language, any device or software to record or view any electronic or other means, the nude body of the undergarments of worn by an identifiable person. So that, again, I believe the language we've added does broaden it. I don't believe we're taking anything out.
Okay, thank you. Would you like to move your amendment?
I would move it.
Do we have a second on the amendment? Representative Ward seconds. Okay, any other discussion on the amendment? Representative Carmichael.
As I say, do this at your peril. You could have made it clear that you wanted to include videotapes by just adding the word. But instead, you're doing something different. And by doing that something different, you may be imperiling prosecutions for no good reason that I can figure out. And folks who say, well, but it's the intent of the legislature and it's very important, the court never gets to the intent of the legislature unless and until the black letter creates question in the court's mind. And I can argue it either way, believe me, I can. But I don't know why in the world that you'd want to give the possibility that people who commit these crimes a way out. If that's what will of the committee is, go right ahead, but I'll be voting no.
Representative Lewis.
Yeah, one other thing I'd point out about the amendment, it is also includes video or other recording. Once again, recording is a pretty broad term. I mean, you're recording an image. So I think with the words image, video, and other recording, we're reaching what we want to.
Yep. I would agree. Just to chime in a little bit, image and photo image can be a still image or it can be a moving image, and I think it covers it. That's my opinion, and I'll support the amendment if it is a tie. So, okay, any other discussion on the amendment? Would you like to close on your amendment?
I'll close.
Okay, committee, you've heard the amendment to House Bill 2518, the Barrett Amendment. All those in favor say aye. Opposed, no. Okay, the ayes do have it. Representative Carmichael would like his no vote recorded. And the bill has now been amended. Do we have any other amendments on House Bill 2518? Okay, seeing none, do we have a motion?
Thank you, Madam Chair. I move that we pass House Bill 2518 as amended favorably for passage.
We have a second. Representative Barrett seconds. Now let's discuss the bill, committee. What questions or comments do you have about the bill? Representative Barrett.
Thank you, Madam Chair. Again, I think this is necessary based on the proponents we had really outlined that this is really increasing the penalties for those who are recording under kids, especially those under the age of 14 is when that penalty really goes up. But we need to prosecute offenders who are doing this and hold them accountable. So I believe this is a good bill.
Any other comments? Representative Carmichael.
Thank you, Madam Chair. I agree that we need to impose strong penalties for people who do these types of crimes. And I think this bill may well address, I don't want to say a gap, but an area in our law where perhaps there ought to be some sentence enhancements. But I want to remind the committee, this carries a bed impact statement 10 years from now of an additional 20, I think it's 20 beds, some number close to that. And if we move more and more to the lock 'em up longer theory of corrections, we have to be willing to pay the price. And the price is to build more prisons. Because if we sit in committees like this one and continue to just increase penalties and take up more and more room in the state prison system, at some point it becomes full. And if we don't build more beds, then that means some people are going to be let out of prison that you didn't intend to let out of prison. So I really think before any of us go home to our constituents and brag about what we've accomplished here today, we need to be also doing the responsible thing. And that is, if you're going to the lock 'em up longer theory of corrections, then you got to be willing to pay the price. And I haven't seen any inclination that we're prepared to pay the price, Madam Chair. Thank you.
Thank you. Any other comments for the committee? Representative Williams.
Thank you, Madam Chair. I just was reviewing my notes from the bill, and I didn't know if Representative Barrett could address the proponents discussing the parental control concerns, issues that they raised, and how you feel like this bill interacts with that concern.
Yeah, so we, myself and Representative Lewis had a conversation about, because I know there was a proposed amendment to cover certain things, like to proving the sexual gratification. Is that the part you're talking about when they brought that up? So the bill, based on our reading, doesn't mandate they have to prove sexual gratification. It just says that that's not, and that's something that is not protected by that protected person being able to record their child. So it doesn't require it. Like he said, it was the prosecutor that testified. It's a negative, right? So it's just saying that it's not required to prove this. But still, I can see both sides' points on it. I just think if you were to introduce that, then there could be some issues. I mean, I'd still vote for it. I think that'd be, I don't know, maybe Representative Lewis could add more context from his position.
Give you a minute to think about that, Representative Lewis, but Representative Curtis has a question or a comment.
Thank you, Madam Chair, and I'm probably taking us off topic here a little bit, but
okay.
Reviewing my notes too, I noted that someone had requested a change from knowingly to intentionally, and I don't know if that was addressed.
Okay, Representative Barrett, you have that?
Sure. So what what they had proposed was, because it says intentionally, they said it's actually a higher burden, but if you actually look further down in the statute, it already requires intent, right, in a lot of ways. So that's why the prosecutor was okay with that burden being raised to intentionally.
Representative Lewis, did you want to comment on the other question?
I don't really have anything more to add.
Okay. Any other comments or questions? Okay. Would you like to close on your motion?
Yes, thank you, Madam Chair. I close and move my motion.
Okay, committee, you've heard the motion to pass House Bill 2518 favorably, as amended, favorably for passage. All those in favor say aye. Opposed, no. Okay, the ayes have it. And Representative Carmichael would like his no vote recorded. Anyone else want to? Okay, great. Well, we passed House Bill 2518. The next one we're going to take a look at is 2613. 2613. And we're going to have Jason give us a reminder on 2613. We actually just heard this bill yesterday.
Thank you, Madam Chair. Donica Short, Office.
Oh, yes, I'm sorry.
No, you're
Yeah.
fine. So again, House Bill 2613 concerns the Crime Victims Compensation Board and fees for conducting examinations of person who may be victims of sexual assault. Again, it moves to the board that they shall establish, the board shall establish and pay the fee for such an examination, and further that the board shall be reimbursed such fee upon cost being paid by the defendant. Again, it adds a provision to 74-7304 to allow the board the power to adopt rules and regulations needed to carry out the provisions of regarding those fees, and to allow monies in the Crime Victims Compensation Fund to be used to pay for those fees.
Okay, thank you. Do we have any amendments on House Bill 2613? Okay, seeing none, I'm going to go ahead and ask for a motion.
Thank you, Madam Chair. I move that we pass House Bill 2613 favorably for passage.
Second by Representative Bohai. Okay, committee, what questions and comments do you have about House Bill 2613? Representative Osman.
Thank you, Madam Chair. There was discussion yesterday, and I'm not sure if there was a clear answer on this. I don't have an objection to what the bill does and what it's proposing to do, but there's a finite amount of money in the Crime Victims Compensation Fund. And it appears that this is going to siphon off some money to another purpose. Now, whether we wish to do that or not is another matter altogether, but the solution might be to add more money into the Crime Victims Compensation Fund to make up this differential, because without that, you have crime victims not getting properly compensated, which is the whole point of the fund.
Okay, anyone else? Representative Carmichael.
Thank you, Madam Chair. I'm perplexed as to why Mr. Santiago, the chair of the Crime Victims Compensation Board, supports this, because I know he's been the chair for as long as I think I've been here. But as best I can tell, this is an unprecedented raid on the Crime Victims Compensation Board. As it stands right now, victims of sexual assault, they get the evidence obtained and preserved. It's a sexual assault kit. And the bill goes to the county. It doesn't go to the victim. It goes to the investigators. the police, the sheriff, i.e. the county. And the county has to pay that bill. And I know the hospital wishes they'd pay the bill sooner. But so what are we doing to deal with this problem that counties are slow in paying the bills? We now make the victims of crime responsible to pay for the law enforcement function of investigating the crime and collecting the evidence. You're victimizing the victim twice. Not only are they victimized by their assailant, now they're being victimized because they have to pay to gather the evidence out of the Crime Victims Compensation Board funds, which are supposed to go to crime victims, not to law enforcement. I do not understand why we are doing this. There is a provision in the bill that says, oh, the defendant shall reimburse the Crime Victims Compensation Board. Well, first, there has to be a defendant. In other words, the crime has to be solved. The unknown sample has to be matched, and you have to figure out who done it. And second, you have to convict them. And once you convict them, they're headed to the state penitentiary for a long time. Their commissary account isn't going to have money available to pay back the Crime Victims Compensation Board. Nobody came in here and said that there was a lack of money for processing sexual assault test kits. We on this committee and the Corrections Committee have addressed that several different times over the past several years to take steps to get the money, and we got the money, to process the backlog of kits, to process the unknown donor, if you will, or unknown assailant kits. So I have no idea why we want to make victims of crime pay for the investigation of crime. That's just not a good idea.
Representative Barrett.
Thank you, Madam Chair, and I appreciate the comments. I would say, obviously, this fund is funded by criminals who, when they're convicted, through that fund. But I don't know anything about the fund. I'm not an expert about this, so I looked to who the proponents were on this bill. And we have the chairman of that board, the division chief for victim services, the general counsel for Kansas counties and associations, the KPOA, and all the other organizations for law enforcement, Saints Heart Nurses, the Coalition Against Sexual and Domestic Abuse, the Wichita Area Sexual Assault Center, and then the Forensic Program Coordinator for Southwest Medical Center. So those individuals are the experts on this, and I'm going to trust them for this decision.
Okay, thank you. Representative Curtis.
Thank you, Madam Chair. I could look it up myself, but do we have a fiscal note on this? I too, just let me say, I too am worried about the appropriations matter. And so I think that we do have to consider that and make sure that we're not leaving the Crime Victims Board in an issue of not being able to cover what they're supposed to cover already.
Yep. So Ms. Shugala, the division chief of the Victim Services Division, said that there is no SGF that would be used. And she said that the Crime Victims Compensation Board gets, first of all, 75% match for everything that they do. And then she said they would receive $815,000 back in federal grants. So it would cost, the actual cost to the program would be $271,000. Crimes Victim Compensation Board can absorb the increased costs with existing revenues through the Kansas Crime Victims Compensation Fund. The fund paid for only by offenders through the judicial system doesn't utilize any state general fund. So I tend to agree with I do agree with Representative Barrett that the division chief does not want their fund to be depleted. And they feel like this would be helpful, I think, in getting it done. And the same with Mr. Samaniego, but no SGF if that was your question.
Yes, and thank you. And that does help clarify. However, I do know that when agencies do run out of their fund balance, they come to us and ask for SGF in appropriation. So I think we do still need to be concerned about that.
Representative Osman.
Thank you very much, Madam Chair. So, I mean, I do agree with Representative Barrett that you look at the list of proponents and it's overwhelming, like including the people that are running the very fund itself. I'm looking at there is a fiscal note. I don't know if this was here at the time that we were hearing the bill. It's dated February 9th. As I look at it, it says, the Office of Attorney General says that it will cost approximately 1.1 million from all funding sources, including $342,924 from the Crime Victims Compensation Fund. $342,000. I don't know. I mean, I know that I don't remember off the top of my head, and no one seems to provide a number as to what the total amount for the Crime Victims Compensation Fund is. I know that last year we increased that amount. And we increased that amount because crime victims weren't getting compensated properly. And this was our fix to that. And now it looks as if we're going to suck up $343,000 from that fund from crime victims to give to testing. And if there was an unlimited pool of money, I'd be all for that. And if there was a corresponding fiscal note or a note that said, we are going to bring from the general fund $343,000 to add into the general fund for this very purpose, I'd also be all for it. Now we're just consolidating resources. This makes sense. I don't know if this makes sense to pull that money from the fund when that's the whole purpose of the fund.
Okay, I did have a question. Did we ask research to give us a balance on the Crime Victims Compensation Fund? Thank you, Jordan. I appreciate that.
Thank you, Madam Chair. So I apologize. I sent it a little bit later this afternoon, so I don't think Lene may have had time to send it out to the committee. But I do have the ending balance that's projected for FY26 and 27, if that'd be helpful. If you'll give me just a second here, I'll pull that document up and I can read that.
Okay, that would be great. Okay, in the meantime, does anyone have any other comments on the bill? Representative Carmichael. Second time.
I can fill this pregnant pause, Madam Chair. If there's a whole bunch of money in the Crime Victims Compensation Fund, then we ought to be getting that money out of the fund and we ought to be getting it out to the victims of crime. We shouldn't be building up a carry-over balance. Conversely, if there's not enough money in the fund, then why would you want to take $350,000 out of the fund to pay bills that are already being paid by counties? This isn't the situation that we had several years ago where there weren't funds available to process these kits. This is just a matter of taking money that was supposed to go to victims of crime and transferring it to counties. That's why the counties support this. They don't have to pay the bill anymore. I don't understand why people want to do this. Thank you.
Okay, Jordan, if you have that amount, that would be great.
I do. Thank you, Madam Chair. According to our KLRD fiscal analyst, Ariana Waddell, who is assigned to the agency, she stated that beginning in FY24, the Office of the Attorney General was authorized to transfer funds from the Victims Compensation Fund to the Crime Victims Assistance Fund, which increased to $500,000 annually starting in fiscal year 24. So I think that hopefully that answers the question about the increased transfer. And then currently the ending balance is projected to be $8.9 million for FY26, and that will increase to approximately $9.0 million for FY27.
Okay, thank you. And I just would like to point out, if you all remember what Mr. Samaniego said, they have applications and they disperse the funds to whoever of the victims apply for funds. So it's not random, just give it to victims. They are dispersing those funds as fast as they can when they get applications from the victims that need that, especially I think it's economic help after they're victims. And so they're not able to just disperse it randomly. It's as asked for by an application representative, or yeah, Representative Sappington.
Thank you, Madam Chair. I believe yesterday we spoke to as well, this came up, that these test kits also cover for victims that don't ultimately press charges. So we are expanding this to people that, and I say this as a proponent of the bill, but we're expanding this to people that maybe otherwise wouldn't get to receive some of these funds. We're still helping them cover those charges.
Thank you. Okay. This would be your third bite, but go ahead.
We have new information now. The fund required a transfer of $500,000 to supplement the fund. And now we're going to give $350,000 of it away to counties. And the second thing is, with respect to what Representative Sappington just said, it's not based on people who do or don't press charges. It's people who make a report. And when the report is made, then the test is conducted. And so the expense is incurred by the county, irrespective of whether quote unquote charges are pressed. When the kit is conducted, the county is on the hook to pay for it. And this just moves $350,000 from the Crime Victims Compensation Board, which dispenses money based upon a formula. It doesn't pay people 100% of their loss, because there was a time when we didn't have an $8 million carryover balance, which is something that we need to look into as well. Thank you.
Representative Curtis.
Thank you. Can I ask a question of research just to clarify those numbers? So there's 8.9 million in the fund balance now. And we are putting in $500,000. Is that annually? And is that where is that money coming from?
Jordan.
Thank you, Madam Chair. So my understanding is that the transfer is actually moving funds from the compensation fund to the Crime Victims Assistance Fund, which is I believe that's the fund that those claims are paid from, if I'm not mistaken. But the full fund itself is what is having that ending balance of 8.9 million. And I'm sorry that I'm not as well versed on the ins and outs of these accounts here. So if we need additional information, I could ask our fiscal staff about that.
Okay, that would be great. And the 1.1 million cost, is that, what period of time is that annually of what they're anticipating?
Jordan.
Thank you, Madam Chair. According to the fiscal note for the bill, it looks like the Office of Attorney General was estimating 1.158 million for, or excuse me, 1.159 million for FY27 and the same amount for FY28. So it looks to me that they're estimating that to be an annual 1.159 million, at least for 2 years.
Okay, thank you.
And I mean, I think we already covered this, but 75% of that's federal funds. Yep, federal funding. Okay, I think we're good. Yes, okay, go ahead.
Thank you, Madam Chair. I'll be quick, and it's about a different topic. I mean, I am generally concerned, like I want to support this bill. I think logistically it makes more sense in how things would be handled and having one point of contact. I am concerned that there was a $500,000 transfer to the fund, and now they're requesting to spend over $300,000 of that for this specific purpose. So I wonder about cash flow. But I think the point I want to raise, and I don't know that there's an answer to this, but it does also concern me a little bit that they are setting the fee and then paying the fee. Like that just feels like a little bit of a potential conflict of interest. Like right now, KDHE sets the fee, so why not allow KDHE to continue setting the fee and have Crime Victims Compensation Board pay the fee? I don't know if there's a scenario in which they would like charge a lower fee, so then it then costs less money for them to administer the program, and if that doesn't adequately like pay for the test to be conducted, for example. I'm thinking through this out loud, but that also feels like it could potentially, I don't know, just doesn't feel, I've never seen that before. So that is just a question that I wanted to raise.
Okay. I'm seeing no more questions. We're going to go ahead and vote on the bill, as long as everyone's good. Okay. Representative, would you like to close?
Thank you, Madam Chair. I close and move my motion.
Okay, committee, you've heard the motion to pass House Bill 2613 favorably for passage. All those in favor say aye. Opposed, no. The ayes do have it. That bill will be passed favorably. Representative Carmichael voted no. And that's it. Okay, thank you, committee. We're done with House Bill 2613. We're going to go ahead and do House Bill 2614. Depending on how it goes, it might be the last one. We have one more I would like to get done. So that's the goal, is to do two more. But this one, House Bill 2614, and Donica, I think that's you.
Thank you, Madam Chair. House Bill 2614 again concerns the Crime Victims Compensation Board and exceptions to confidentiality of records. That first exception provides that records may be obtainable from the board upon a finding that the records given to the board were not previously available to an agency investigating or prosecuting child abuse or neglect. And that second exception provides that records may be obtainable from the board upon a finding that the records given to the board are wholly or partially false or fraudulent.
26. Okay, thank you for that. Okay, are there any amendments on that one? Okay, seeing none, we'll go ahead and have a motion on House Bill 2614.
Thank you, Madam Chair. I move that we pass House Bill 2614 favorably for passage.
Representative Lewis seconds. Okay, what discussion do we have on House Bill 2614? Questions or comments, committee? Representative Lewis.
Yeah, I seconded the motion because I think this is a good bill. It simply expands the ability of the Attorney General to provide information with respect to child sex abuse and any instance in which they believe they were the victims of a fraud, so that they could be prosecuted. So I think this advances the cause of criminal justice.
Okay, thank you. Okay, any other comments? Okay, Representative, would you like to close on your motion?
Thank you, Madam Chair. I close and move my motion.
Okay, committee, you've heard the motion to pass House Bill 2614 favorably for passage. All those in favor say aye. Aye. Opposed, no. It was unanimous. House Bill 2614 is passed. All right, we will go ahead and do House Bill 2521. When 2521. It's about the Kansas Tort Claims Act. And Jason, I think that was you, if you could remind us about that one.
Thank you, Madam Chair. 2521, keeping it short, is the one that expands the Kansas Tort Claims Act to include child placement agencies that contract with the Secretary for Children and Families under the definition of state in that act.
Okay, are there any amendments on House Bill 2521? Okay, seeing none, we'll take a motion on House Bill 2521.
Thank you, Madam Chair. I move that we pass House Bill 2521 favorably for passage.
Seconded by Representative Bohai. Okay, committee, what questions or comments do you have on House Bill 2521? Representative Carmichael, you're first.
Thank you, Madam Chair, and I'll do my best not to make 3 appearances at the mic. I'll try to cover it all the first time around. This is a bill that we are ultimately responsible for the problem. The problem is the insurance companies for nonprofit, or for for-profit and nonprofit, I think, organizations that take care of children are saying we are in a new world, a new environment. We no longer have the certainty that we once had about the extent of our liability for claims, particularly claims related to sexual abuse of children, in this case in a foster care setting. Well, you ask, why are we responsible? We're responsible because we rightly expanded the statute of limitations for these crimes. We have expanded the statute of limitations to what I think is probably the maximum amount allowable under the Constitution, but I know that there are still gaps. There are still some people that a lot of folks would still like to give some relief to some of the victims who've been left out. But the end effect of this is that now we are reaching back for claims or events that occurred many years ago, and that expanded the liability of the foster care carriers, foster care companies and their insurance carriers. This isn't as a result of changing the laws about sexual abuse. This is about the civil consequences of the abuse of children in foster care. And what we have done to try to meet the complaint of the insurance companies is to now bring these claims against foster care providers under the Kansas Tort Claims Act. That's not a good idea. The first reason is it re-victimizes the victims of these crimes. We expanded the statute of limitations to allow them to go to court to make claims for their damages against the persons and the companies responsible for what happened to them. But now, instead of being like any other citizen who has a right to sue for unlimited damages for pain, suffering, emotional distress, the things we call non-economic loss, we are going to limit these victims to the $500,000 limitation under the Kansas Tort Claims Act. So you may have heard about a jury last week that returned $8 million in Wichita to the family of a young man who died in custody. That will not be so for the victims who've been abused in foster care, because we're going to limit them to $500,000 under the Kansas Tort Claims Act. Now, to be technically accurate, if the providers buy insurance that insures them for more than $500,000, then it's whatever the amount of the insurance is. But the whole argument is the provider, or the insurance companies and the providers can't afford the insurance anymore, so that seems pretty unlikely. But there's more to the Tort Claims Act than just the $500,000 limitation. We also heard testimony about the immunity provisions, Kansas Tort Claims Act, and the discretionary function exception. And I don't want to get into a big argument today. The hour is late. But suffice to say, it gives the wrongdoers one more defense. It allows them to say, well, it was within our discretion to do this or not do this, and therefore we're not liable to the victims of a sexual assault that happened in our facility because of our negligence, because it was discretionary. The next thing that we need to understand is that the Kansas Tort Claims Act, best I can tell, and I don't see any change in this statute, takes the insurance carrier, and for that matter, the foster care provider, off the hook. It makes the state of Kansas pay those damages. Those damages are limited to $500,000, but now it's the state's liability, not the responsibility of the businesses that caused the damage to children. The third thing that I note is, generally, the Kansas Tort Claims Act comes with a duty to defend, that the responsible employer, if you will, or entity, in this case the state of Kansas, not only do they have to pay for the damage, they also have to pay for the lawyers to defend the damage. Now, my guess is that the Attorney General in this circumstance, rather than using his staff to defend these claims, will probably hire outside counsel. We don't know how much that's going to cost the Attorney General. What do we get for this? What do the victims of sexual abuse in foster care settings get for this? What they get is less money in damages because of a $500,000 limitation. What do the taxpayers get? They get the bill for somebody else's fault or negligence. What does the Attorney General get? Well, he gets to hire more lawyers to defend more lawsuits, and probably with outside counsel. This proposal is beneficial to the insurance companies for foster care providers, but it's harmful to the victims of sexual assault in foster care settings, and I can't support this. Thank you.
What other comments do we have? Representative Barrett?
Thank you, Madam Chair. Could I ask the revisor if, when it comes to liability, is it the state that's liable under this bill? Or would it be on the contracted company?
He's thinking. Jason?
Madam Chair, off the top of my head, I think the former representative was correct that the state is the one that is accepting the liability and is paying the claims, also defending the claims. I don't think any of that was incorrect.
And that's true now also, or if this bill is passed?
Madam Chair, that might be a difficult question because it might depend on the contract. And I don't know enough about the contracts to understand who is actually paying, but based on the insurance discussion, I'm guessing the state is not the one assuming the liability under those contracts, just from the context, but I don't know that for sure.
Okay, thank you. Representative Lewis.
Right, so this is obviously an important issue. I was, and still am, of the assumption, I wouldn't say opinion, because I haven't studied it sufficiently, that no, these private entities would be paying any liabilities, not the state. But I'd just say that, you know, if we can't clarify that, I think that's something we really need to know. And I could go on and address some of the other issues that Representative Carmichael raised, some of which I agree with, some of which I don't. But I guess I might suggest that we table this and clarify that very important issue. So I'll make a motion to table it.
Hang on just one second. What you want to know is is that question that we just asked Jason?
Yes.
Okay, I mean, okay, well, I don't know what your motion was going to be, but I'm fine just putting this off till another day if we need more information.
You can do that on your own and there won't be a motion. I just think we need to get that clarified before we proceed with a vote.
Okay, Representative Bohai?
So it's my understanding that currently the Tort Claims Act covers charitable healthcare providers, hospitals owned by a municipality and the employees thereof, local health department employees thereof, indigent healthcare clinics and the employees thereof, the district coroner or deputy district coroner appointed and amendments thereto, and community mental health center and employees thereof. So like, if we're covering those aspects and we privatized and we decided to go this route, it sounds like we're doing cleanup because now we've caused more of an issue. And I'm afraid if we don't do something, we're going to have less organizations that can even be providers, right? Like, is this going to, if we don't act, is it going to price them out of being able to provide care to the people that we need help providing care to?
Okay, thank you for that. Okay, committee, what I think I'm going to do is if you would like to make a motion to, gosh, I don't know if it's tabling because I don't want it to be I'd like to discuss it a little bit, but I'm curious the will of the body. If you would like more information or if you're ready to vote on it now, we can do that. So maybe we could just have a little bit of discussion and I could figure out kind of what the will of the body is. Representative Schreiber.
Thank you, Madam Chair. I'm ready to vote. And the way I look at it is the state made the decision back in mid-90s to privatize child placement. I think the state bears that responsibility now with these private placement agencies, which will likely go out of business if they don't get some relief, which then puts it back into the state's realm and they'll take over it. And the costs will be incurred by the state totally.
Okay, thank you for that. Appreciate that. Anyone else like to voice an opinion? Representative Lewis, did you want to answer any of Representative Carmichael's other things that he had or not? I don't want to put you on a spot, but if you had mentioned that, but I don't want to.
Well, as far as we did have this issue of the discretionary function, and the prospect was raised that somehow they would be able to, they being the providers, would be able to say that what they were doing with the kids negligently was a discretionary function. I did look into that, and although there may be some arguments one way or the other, I don't think that discretionary function immunity is going to apply in the circumstances. That really pertains to government entities that are making policy decisions that end up causing harm to somebody. That protects them against liability.
Okay, thank you. All right, any other comments? Representative Carmichael.
On the discretionary function exception to liability, I don't really disagree with Representative Lewis on that. It's an argument that could be made. I don't think it's the strongest argument, but I only raised it in an attempt to be complete about potential flaws and things we don't know the answers to. And I won't repeat the rest of what I had to say, but I do not, for the life of me, understand why you'd want to expand the statutes of limitations to give these victims the opportunity to sue their assailants and the companies responsible, and then turn around and limit their damages to $500,000, and then go so far as to say that the foster care providers have no liability anymore, that it's all on the state. One of the purposes of the civil justice system is to deter people from failing to exercise reasonable care. And the more you insulate businesses, and these are businesses, the more you insulate a business from the consequences of its negligence, the more people get hurt. In this case, it's foster kids.
Did you have a question? Okay, Representative Barrett.
Thank you, Madam Chair. I'm certainly on the fence on this because I think Representative Schreiber made a really good point, which is that if we didn't have the liability coverage and let's say the insurance companies would no longer cover these entities and they go out of business, well, it's going to revert back to the state anyways and won't be contracted agencies if they can't, survive under these circumstances. And if this were state controlled, this current act would take place. On the other side, I would like to see those damages, even if it's capped at $500,000, go against the organization, not the state, because I want that organization to have that pain come out of their profits or whatever it is if because of their negligence a child was exploited. So again, because that's not answered right now, I'd probably be a no vote on it.
Okay, thank you. All right, committee. Okay, just one second. I have one question. Okay, this is what we're going to do, committee. We're going to go ahead. We have a motion and a second on the table to pass this bill favorably. We're going to vote on that. If you would like more information or if you don't agree, then it's still in the committee if it doesn't pass favorably. And I can bring it up in 2 days. But if you are sure that you like the bill and you want to go ahead and pass it out favorably, then I would encourage you to vote that way. And that's how we will decide what the will of the committee is. So with that, Representative, would you like a question? Who? Lewis, Representative Lewis.
So if we hypothetically vote this down,
Mhm.
you're committed to bringing it back in 2 days?
Absolutely.
Okay, all right, thank you.
Not Friday, 2 days would be Thursday. We're not, my plan is not Friday, so yes, I'm committed to that. Okay.
Thank you.
Any other questions? Yeah, Representative Williams has a question.
Thank you, Madam Chair. On just like a point of order, if we vote on it and it votes down, is the bill technically killed?
No, no, it's not. It's still just not passed out. It's
Okay.
still in our committee. That's, if I didn't make that clear, that's what I meant to say.
Okay, thank you, Madam
Yeah,
Chair.
it's just not passed out. Okay, so would you like to close on your motion?
Thank you, Madam Chair. I close and move my motion.
Okay, all those in favor of passing out House Bill 2521 favorably for passage, say aye. Opposed, no?
Oh,
Okay, I think I'm going to have a show of hands. Okay, y'all don't want a show of hands? Let's do it again. All those in favor say aye. Aye. Opposed, no?
no.
Okay, I believe the noes have it. And we will come back in 2 days and take a look at it then. Okay, thank you, committee. Now, tomorrow, I don't plan on working anything. If we were going to work something, I'm just saying it would be the bill we heard today, the second one, that was very, we had one proponent, or it's 2612. I'm not planning on working anything. We're going to hear 4 bills tomorrow, so just be prepared for that. But if we had extra time, we might try to get one done and worked, and it would be that one. And then on Thursday, we also have bills to hear, but we will also work a lot of bills on Thursday. So just be prepared for that. Okay, thank you. We're adjourned. Appreciate everyone so much.